Good morning. Welcome to Long Live Third Parties Podcast. Free Press Media Press, Inc., a third parties books publisher, sponsors this podcast. I'm Andrew Bouchard. Today I read the case Rogers v. Corbett, 468 F3D 188, Court of Appeals, 3rd Circuit, 2006. Friends, we got another example of coalitions in this case. We love coalitions, so let us praise coalitions in this case. Friends, this case involves three of your favorite third parties. The Green Party of Pennsylvania, the Constitution Party of Pennsylvania, and the Libertarian Party of Pennsylvania. Two of those parties I voted for. The other one I would consider voting for if they were on the ballot. Yes, I voted for the Libertarian Party and the Green Party. How about you? Which of those three parties have you voted for, friends? Let's read what happened in this case. It says, quote, plaintiffs, a group of minor political parties and minor party nominees for statewide office, challenged the constitutionality of Section 2911 of the Pennsylvania Election Code 25 PA Statute 2911 parentheses B as applied to minor political parties and their candidates. End quote. We love to see challenging the constitutionality of that. Like we've already discussed in this podcast, we love the coalition aspect of this case. This case involved our friends wanting to get on the ballot and having to deal with the percentage requirements. As it says, quote, plaintiffs brought an action for declaratory and injunctive relief pursuant to 42 U.S.C. Statute 1983 on the grounds that Statute 2911B violates both the Equal Protection Clause of the 14th Amendment of the United States Constitution and the minor political parties' rights of freedom of association under the First Amendment. End quote. Yes, again we're seeing our third-party friends invoking the First and 14th Amendments. In a great number of these trials we've discussed on this podcast, that is a key strategy, invoking those two amendments. Not every single case, but it seems almost every other case at least involves invoking those First and 14th Amendments. So we applaud that. We cherish that. Also, this decision says, quote, alternatively, plaintiffs have proposed other schemes to allow minor political party candidates to be placed on the general election ballot after demonstrating a lesser level of support. Plaintiffs also urge that minor political parties ought not be subject to any signature requirement in the light of the fact that they have already qualified as a political party. End quote. Let's admire the ambition required for asserting other schemes, as they say. What do you think about that argument in that second sentence of what I just read? Do you think that if they have already qualified as a political party, they shouldn't have to do any more ballots, any more petitions? What do you think, friends? What do you think? The district court here said they were not in their rights because this law didn't hassle them very much. So that's why our friends appealed. They thought otherwise. It states that our friends are suggesting that the 2% needed to get a minor party recognized, as well as the 2% signature. When you put them together, it's too much. They cite this case in Maryland called Maryland Green Party versus Maryland Board of Elections. But this court here says it's different. That doesn't apply. Also, they say the following. I want you to think about this, friends. I want you to think about the ramifications. It says, quote, moreover, the two-tiered nature of the minor political party process is consistent with, albeit different from, the the two-tiered process for major political parties. Going back to the Anderson methodology, we conclude that the two-tiered nature of the law does not constitute an unacceptable burden. End quote. So friends, do you think they should be different? Do you think the minor parties should have the same processes of the major parties? Or do you think it doesn't matter? Are you willing to say we're going to keep forging ahead regardless? Or do you want to remove this obstacle? Do you think it's fair? Unfortunately, the court ruled as follows. It says, quote, "For the reasons discussed above, we will affirm the district court's denial of the plaintiff's motion for a preliminary injunction. In addition, we will affirm the suggestion of the district court that the Pennsylvania General Assembly consider enactments that will simultaneously meet the identified state interest, but also allow for a less ponderous means of ballot access for minor political parties in Pennsylvania." End quote. There's a small prize, a consolation prize, a small consolation prize. The idea that the district court is suggesting to the Pennsylvania General Assembly to propose a new law. It's not legal weight in any sense. It's more a recommendation. So I don't know if they're going to pay attention to that, if they paid any attention to that. Still, they do concede one of our friends' points. That is something. Our friends didn't win everything here, but let's admire them for taking this to court. Long live third parties. Goodbye.